I've been to a lot of places before where I'll ask them about their safety policies and procedures. I say, well, tell me a little bit about your safety policy. What's your safety program about? Well, we really want everybody to be safe. That's our number one priority. I say, okay, well, talk to me a little bit about that. Well, that's really our goal. Our goal is to be safe, and you kind of see where it's going. There's not really a clear goal there. They just want everybody to be safe, which is admirable. I hope they don't want anybody to get hurt. How many of them actually hold their employees and their managers accountable for safety, right? They actually hold them accountable for it. They link their safety performance in their overall review process. How many of you have some kind of review process of your employees within your company, where you do it periodically? Okay, a couple people. Having some kind of review process where it may be quarterly, it may be monthly. A lot of them are either twice a year or annually. Okay, every company I work for is at least have one at least once a year. But rarely do I see the safety performance actually linked in their review process. And in these companies that really do safety well, they do this. They hold their managers responsible, and when it comes for their yearly review time, if there's been some issues with the safety program, maybe they've had an injury, one of their employees had an injury, and we're talking about supervisors here. Say, for example, they didn't report the injury right away. And this happens quite a bit. David and I run into this all the time, and that's Sue does, where we hear about the injury 3 or 4 days later. You hear about the injury 3 or 4 days later, a week later, a month later. I had one recently, it was 3 months after it happened. Okay? And the employer had really already lost control of the employee at that point. They were out of work, they weren't coming around, so I better report this to workers' comp. By that point, we couldn't even hardly get a hold of them. Okay? So, if they're required to report the injuries right away, are they held responsible when they don't? Is a supervisor held responsible when they don't report it right away? Okay? This is just an example. There's a lot of different examples we could use. I like this accountability slide. This is kind of the point of it all. You've got a problem with avoiding personal accountability. Well, whose fault is that, right? Every employee, from the most senior to the newest employee, should understand what is expected and required of them, right? They should understand, as part of your safety program, hopefully you're doing more than, we tell them to be safe, we give them a hard hat, we tell them to be safe and be careful out there, okay? Well, that's great for somebody who's got 25 years of experience, who really knows the business, understands it. That may not be so great for somebody who's new to the business, who doesn't understand the business. This often requires more effort than just what a safety meeting will do. Okay, I go into a lot of companies, and David does too, where their safety policy really is just, it hinges on safety meetings. Safety meetings are great, but have the companies, have you shared clear expectations with you? Are there clear goals for the employees to understand? Set some safety goals for management and non-management employees. This may take some thinking. I mean, you may have to sit down and discuss. You may have to get on the internet. You may have to call somebody like me or David. Say, what are some of our goals for our management employees and our non-management? Some of them should be similar. Some of them may be different. Okay? Communication is always the key. You've got to communicate the goals. It's not really fair to your employees to hold them up to a standard you never communicated it in the first place. Seek employee input. How many of you have, probably don't have to raise your hand on this, but how many of you have a process in place where you seek employee input on what the goals and the expectations will be? Okay? That's what a lot of these the safest companies do. They have a process in place where they seek employee input into what those goals. How much better do you think the buy-in to your safety program is if you seek an employee's input? If you get their feedback on maybe what some of the safety goals should be, or maybe maybe it comes down to something as simple as what kind of safety glasses you buy, or what some of the safety rules may be. Now, there are going to be some hard and fast rules that you can't mess with. Okay, there are going to be some procedures, and there may be some facility issues where you've got to have things a certain way. But there may be some other goals that you can seek a little bit of employee input into that. Okay, and then those safety goals, communicating them. It all goes back to keeping the communication lines both ways. Okay? If you're just dictating a lot of rules, I mean, how many of you, when you go to your employer or you start a new job, they give you a list of 20 or 30 rules. You have no say-so. You sign a statement and you're done. Okay? That's one way to impart it. Okay? It may not be the best, may not be the most effective way to communicate, to set it up. SMART goals, specific, measurable, achievable. I went into a company one time personally, this is several years ago. They were having on average about 200 claims a year, 200 injuries a year. Okay? This is a fairly big outfit. Okay? And we got to discussing some of their goals. They had kind of change in thinking. They wanted to kind of ramp it up. I was the new guy. I was the new workers' comp guy come in, so they were wanting to tell me what they planned to do and some of their goals. Their goal, and I'll never forget this is down in the Charleston area, by the way. Their goal was 0 injuries next year. That's a great goal, having 0 injuries. How realistic is that goal? 200 a year. Now Gavin, this person had not described to me the changes in their safety program. Hadn't described to me what they had done differently, what they had planned to do, training they had done, maybe new hiring procedures. They haven't discussed any of that. His goal was around 200 injuries a year to 0, and he communicated that to his employees. That was going to be the goal. And I said, well, what's going to happen that first or second day when that goal is done? It's over. Your goal's shot. I mean, is there a backup plan for that goal? Probably a lot of Gamecock and Clemson fans in here, and maybe, I don't know what David is in that.
NC State.
NC State, that's right. You'll hear most college coaches, most basketball coaches, football coaches, I'm thinking of Clemson and Carolina at this point. You hear a lot of them beginning of the year, the press will ask them, what are your goals for the year? What are your goals for this coming year? And of course, a lot of them want to win the national championship and all that kind of stuff like that. Of course, that's the obvious goal. But if that's their only goal, in the first game they lose that game, or the second game, or maybe the fourth game, that's the only goal they have. They run a risk of losing their team because that goal is shot. That's the only goal. Now, I know I've heard Spurrier, read it in the paper many a times. Usually his goals are what? Win the first game, right? Win the first game. We've got a list of goals in the locker room. We've got a bunch of them. Win the first game, win all our home games, win our conference games, win the Clemson game, win the bowl game. If we do all that, we've got a chance to win the national championship. To me, those are more realistic goals than having a goal of 200 injuries a year to 0. Because as soon as you start having a couple, your goals are shot. So you need to have multiple goals. Anybody ever heard this phrase before? I mean, it can apply to a lot of different things, right? If you don't measure it, you can't manage it. If you can't manage it, you can't improve it. I keep thinking about David when I'm going to hear this, because this is something I might hear him say or something like that. We've got to measure it. We've got to measure it, right? If you've got safety goals in place, do you measure them? And I'm not talking about improving your safety goals. Your safety goals right now, any kind of goals that you have, do you measure them? Do the employees know how you measure them? If you don't, if your goal is just we want to be safe and not have any injuries, well, you may not be able to measure that. So if you can't measure it, you may need to set some goals that you can measure. And then how do you manage it? I mean, what does that mean? If we're going to measure it, I know David in our company, because we've talked about it, we've got certain goals that we want to achieve, and we've got certain measurements. If we miss one, it doesn't necessarily mean we're going to miss the second. We might be able to get the second. But there's multiple goals in there. One might be a better presenter for me when it gets finished. That might be my goal, so you've got to get a lot better. So how do we manage it? What does this look like? How many of you have an internal safety inspection process where you do safety inspections on your own? If you're a manager or an owner, how many times have you done the safety inspection yourself? How many times have you done it yourself? Walked around, showed up on a job. Say you've got a job site. I was in Sumter one time talking to a contractor down there, and I asked the safety director, how many times do you actually go out to the job site just to show up? He says, well, I've done that. I said, well, what are you normally looking for? His answer to me was, I'm usually just making sure the guys are doing what they're supposed to be doing and kind of paying attention and that sort of thing. More production oriented than actually the safety goal. we talked and worked through a process to where he eventually got to where he would actually borrow another employee's car in the parking lot, would actually go out to the job site and just drive up on the side of the road and show up, see if everybody was doing what they were supposed to be doing, wearing their hard hats, wearing their safety gear, wearing their gloves on the side of the road. This was doing utility type work. Do you have goals for, most of us, a lot of companies have this, goals for reporting injuries, right? If somebody gets hurt, you want to know about it, okay? And if you don't have that goal, you need to put that in. Do you hold people accountable when they don't report it immediately? If they get hurt, you want to know about it as soon as possible. If you don't, do you hold the employee accountable? Hopefully you do. You have a process where you can have some kind of disciplinary policy in place where you hold them accountable. How often do you also hold their supervisor accountable too? The supervisor said, well, I didn't know about it. He didn't tell me. Why didn't you know about it? Maybe you should have known about it, right? Maybe you should have known about it. Have you ever heard of a job hazard analysis? Okay, a lot of companies use job hazard analysis where you actually go with someone, and David and I, these are some of the things that we can show people how to do. Okay, this is kind of a sales presentation too. But you actually go to a job, a particular task, and you look at all the potential hazards that could come out of that situation. And you try to address the potential hazards that could be there. And you do that on a job-by-job basis. Maybe you go to one specific, a lot of times you'll see these in manufacturing plants where they'll go to a certain process and they will stand there and look at a particular piece of machinery and they'll say, all right, this is what could happen to this machine. If this machine's not guarded properly, somebody could have a serious injury. Well, so what are we going to do about it?
And many times you'll do what they call a what-if analysis. What if the power goes out? What if this other process next to us has a fire? And you address things that way also. It just helps you to think about any possible thing that could happen.
And that's another thing you can get employees involved in. You have a manager there doing it. Maybe you have a couple of managers going out and doing that. Maybe you pull in somebody from the outside, maybe an outside consultant. Maybe you bring in a department person from another department, a fresh set of eyes to look at that procedure and say, okay, this could be an issue. What if is a great? What if this happens? What if this happens? Is it guarded properly? Do we have this situation? And then, of course, partnering with outside consultants, OSHA, insurance representatives. Most people don't want to partner with OSHA, but they say, well, yeah, we partnered with them, all right. They gave us a bill and we paid it. So that was our partnership. But outside consultants, people like David and I encourage my customers all the time. I say, call me. I may not have the answer, but I will work to find you an answer for the situation you're looking for. I'm not the safety expert, of South Carolina by any stretch of the imagination. But if you present me a problem or an issue as far as safety goes, I want to help you. If I can't answer it, maybe David can answer it. Maybe one of my other coworkers can answer it. If he can't, maybe one of my buddies at OSHA can answer it. And I'm not calling them and ratting you out either. You're my customer, so I'm like, hey, so and so from up in real estate company up in Greenville told me. So really, let me check on that. So we're here to help. That's part of our job. I like this sign. One of my sons found this sign. He really likes this. Sometimes we can miss things. We have the pretty safety policy. David and I have seen this a lot of times where you go into a company and they got a beautiful safety policy sitting on the shelf, a little dust on top of it, but it's sitting up there. Beautiful safety policy. But nobody's doing some of these defining goals and managing and measuring things. They're not actually using the safety policy. So the sign has sharp edges. We see that, of course, and you can't see this from here, but the bridge is out ahead. So you kind of sometimes you can miss the point. So another thing that a lot of companies do, some of the safest companies do, is their leadership. And this is a challenge for leaders, owners, managers. Their leadership sets the example. Okay. I'll show you one example of this from a worldwide perspective. And you can read, and pay attention to, you'll read it for yourself. Pay attention to his little placard here. And I found this on the internet. I mean, I knew about this guy, but I found it. This is the way they describe him. Notice one particular thing about the way they describe a manufacturing giant in the world, really. Read that. O'Neill galvanized Alcoa's workforce by setting high standards for occupational safety, transforming the company's financial results in the process. During his 13-year reign at Alcoa, As it reduced workplace injury rates, Alcoa's revenues increased from $1.5 billion to $23 billion, while net income increased from $200 million to $1.5 billion. He also worked in the Bush administration as cabinet member too. They got him out of Alcoa and pulled him up to there to try to help. Anybody notice anything in particular about a man who's led his life in the manufacturing? Alcoa is a worldwide aluminum manufacturer, okay? Anybody notice anything about his Hall of Fame inductee for the Manufacturing Hall? It's not quite the NFL Hall of Fame, but it is a Manufacturing Hall of Fame last year. Anybody notice anything about his resume there that's kind of interesting? And this is not pulled from a safety site. This is pulled from a manufacturing site. The first thing they are mentioned, setting high standards for occupational safety. That's the first thing a manufacturing guy who's led his entire life in manufacturing. That's the first thing that's mentioned. And like I said, I didn't find this on the safety engineer's website. I found this is on manufacturing information website. He really made his name in occupational safety, setting high standards for his employees. And this is some of the ways he did that. When he first took over back in the, I guess, early 90s, late 80s, early 90s, they were having so many injuries that it was really, you know, the managers knew about it. Now, this is a huge company. It's a worldwide company. One of the first things that Paul O'Neill did was he visited 175 plants. That's every single plant worldwide. That's the first time they'd ever had anybody in that kind of position in their company do that. So he visited every single one of the plants. That takes a long time. As somebody who travels around South Carolina and visits a few customers here and a few customers there, that took a long time. He often started his speeches pointing out fire exits, something I didn't do. Hopefully you saw these. He often began his speeches at the plants by pointing out safety issues. And he set examples by wearing his hearing protection and things like that. I used to work at a facility where the plant manager would come around about 2 or 3 times a week. And often he would have his safety glasses on. But we knew you got to wear your safety glasses. If the owner is doing it, the plant manager is doing it, we're going to have to do it too. A few other things he did. He asked for daily safety reports from around the world. Okay? He wanted safety reports every single day. Not every week, not every month. He wanted them every single day. And one time, he had the date and the name in there, I took all that out. One time he fired a guy in Mexico, one of his managers down there. And this is not a manager this is a plant manager over a plant or several plants in a country. He fired him because he didn't send him a daily safety report. It's pretty serious, right? How many times do you think he had to do that again when they found out about it? He probably fired one guy, and he probably didn't have to do that too many other times. Because if somebody wasn't going to send him a daily safety report, now I have a feeling he didn't do it just once, probably did it a couple times and did that. But he did do that for that reason. Again, he set the goals, the expectations were clear, laid it out for not just his employees. Now, in most workplaces, an employee would feel like, yeah, they'll fire me if I do this or do that. But a lot of times, the supervisors aren't held to that same standard. In this case, they were. I want to show you a quick video. I'm basically finished with some of those traits there. Defining clear expectations, measuring your goals, managing your goals, and then supervisors, owners have to lead the way. They have to. Employees will notice. As an employee of a company, I notice when I'm asked to do something that the president won't do, or the owner won't do. Or if I have to go to a job site and put on my safety glasses, and the owner comes out there, he stands over there in his suit and tie, or whatever it might be, and he doesn't do it, I notice that. I'll never say anything about it. I'll never voice that. I'm certainly not going to walk up to him and hand him a pair. But I notice. I notice. And the message is communicated, well, there's a set of rules for me, and there's a set of rules for him. And they're different. Okay? That's okay. If you want to view it that way, that's fine. But you're never going to get to that level that some of these companies talk about. Because if somebody like Paul O'Neill had a $1 billion company can do it, make it a priority, a lot of us can do it too. And I'll make that challenge for ours. In fact, David will go to Bill Bond soon, and we'll discuss that. But those are some of the clear expectations we talk about, laying those out. I got a little video on you. I think it's a real really cool video. It's about a near miss. This person doesn't get hurt. But here's the situation. You'll notice in the video, and I'll set it up a little bit. He's got his hard hat on. He's got his safety vest on. You may be able to tell around this accident site, or almost accident site. They've got barricades up. Just looking at it, it looks like a pretty good job. Now, some of you are familiar with this type of work. Well, I've noticed immediately it's not a pretty good job. It's a very dangerous situation. But on the surface, just looking at the guys, if you didn't know really what they were doing, you say, they're doing a good job. They've got all their stuff on, and they're doing what they should be doing. They're not doing what they should be doing. And their supervisor is watching all of it. So, a year from now, when they're protesting this in a hearing, and he says, hey, we had just started that job. Guys had just got on site and was trying to angle out of it. Supervisor just told him, we've been here 3 hours. We've been here a long time. Been long enough to see the video, go over to the barricades, long enough to set up all these barricades, got everything right. If you don't know anything about that work, right, he's got his hard hat on. We go to a lot of job sites where if you just take a quick look at things, safety looks pretty good. Clean floor, guys wearing their safety glasses, maybe you got a reflective vest on. Looking pretty good, and those are important. Those are all important things. But from our point of view, because we see so many different types of job sites, an outside person, maybe an OSHA person, an outside safety consultant, they come in, they see so many job sites, they see potential problems. The first thing, when I saw this video, because I've done a lot of trenching inspections over the years, when I first saw this video, in an instant, I'm like, holy cow, this is awful. Of course, I didn't expect it when I saw it, I think it came in on it. But it did. You see all the traffic driving around, vibrating the ground and things like that. That's why he's videoing. He videoed the car. The car coming right by, vibrating that ground. He's getting all that documentation for his file. Because these guys aren't doing it. They're not out there taking pictures. They're working. He's taking pictures. Like, okay, we got all this. A year from now, this will be important. But the dirt that fell on him, that would have easily crushed him. That would have killed him before he hit the ground. It would have hit him so hard. Because about a cubic yard of dirt weighs about 3,000 or 4,000 pounds, depending on how wet it is. Okay? And that was more than that. So that caved in on top. That would have just easily pancaked him. And when I mean pancake, that's what I mean, because I've seen pictures of that. So, but the supervisor, did you hear what he said? He said, who's in charge out here? And he looked right up. The supervisor was standing right there watching the whole thing. That's also important from an OSHA standpoint. Okay? It's also important from a safety. We can learn a lot from a company by seeing this wasn't some rogue employee out there working on his own, breaking the safety rules, right? They had a supervisor observing this. The supervisor was watching this. The supervisor obviously was okay with it because the employee was there. So it kind of goes back to that, who's being held responsible in the company? Chances are they would say they've been trained. They know the dangers of working this. It's probably not the first time they've ever done this work. Okay? This is designed to protect them. This is a trench box. But it's not tall enough. They need another one. They need them stacked. Obvious problems. But the supervisor, and we've done this, David and I've done this many a times, he would say he's been through the training classes. But does the company have some clear expectations? Is he doing self-inspections? Does he have any tools where he's done a self-inspection of his job site or his workplace? No, there's no way. It's obvious. But he's got some safety things. He's got the less important things on, and they're missing the big picture. Some of the safest companies out there have learned maybe the hard way. They've got the little things down, and they've also put some of those big picture items into place that we've talked about, setting those clear goals. If you need any help doing that, please let us know. Okay? A lot of times when we come into a place, we get to talk to you or maybe a couple of your employees, but we're always there to try to help you with this stuff. Sometimes it may take going to all your facilities, walking around, maybe interviewing your employees. Maybe you don't want to know what they would think about your safety program. But I promise you probably would benefit from that. And we're pretty easy to go to. Vic?
Based on what state that is, if there was a serious accident or fatality, that supervisor there allowing that to happen, he's looking at jail time.
Depending on the state, that's right.
I'm not an attorney, but
You got what I'm saying beside
rule there. That right?
In South Carolina, that probably would not happen. I mean, but it has happened nationally.
We had one where a guy was supervising, they were on scaffolds, and the scaffold didn't have any railings. 3-4 guys fell, one died, and the supervisor was there observing it. Now, if you're not there, they come early to the job. I mean, you can't sleep with these guys all day long, but if you're observing him doing an unsafe condition in certain states, your butt's in a crack. I tell you that right now.
Well, that happened in North Carolina. We were talking about earlier, Hamlet, North Carolina, back in the early 90s. And that's an interesting case. If you ever want to Google a case, type in Hamlet, North Carolina, chicken plant fire, and read about that. And the owner of that did go to jail for a period of time. So, in fact, they had a fire there, and they had locked the doors, locked the exits to keep people from stealing their product. They would go out and take it, put it out. I think most companies deal with some of that kind of stuff. His answer was to lock the exits and chain the exits. And when those people died, they found about 14, 15 people right near the door. They had actual fingerprints inside in the door.
The doors were chained back.
They were chained. They were chained, and they had finger scratches in the actual metal of the door. People scratch it. They actually took that door out. And they put it in a museum somewhere. They got that door. But the owner of that did go to jail for a period of years. And I think when he got out, he passed away right after he got out. So. But yeah, Georgia, Vic was asking about North Carolina and some of the resources there. That woke up North Carolina because they had determined that they hadn't had a safety inspection from an outside company in a number of years. Of course, South Carolina had an incident down at the beach years ago with a bungee thing too. So those things disappeared from the beach for a long time. Now they got one down there again. But, there's, you don't want to ever end up on the news on something like this. You don't, especially on YouTube. Think about this. People in 25 years are going to see these guys on YouTube. So, and people like me who copy it to the hard drive or something. But does anybody have any questions or comments about that or anything? I mean, I know it's just kind of broad, general principles, but part of our job is to help companies maybe identify some things that they may not see. You work there all the time. You could come into my workplace and probably spot some things right away that I've been overlooking for years. I mean, that's just kind of the way human nature works, right? I mean, we see things from other people. America's Got Talent. There's no count bums. I could do that, and then you get on there and they start calling you a no talent bum. So, I mean, that's just kind of human nature, right? We spot things in our own environment we may not see, but somebody else comes in, they may be able to see some things. So, if we can ever help you with that, please let us know. We're available to come out either, just have a discussion with you about some things, or if you ever want us to come out and actually walk around your facility, take a bunch of pictures. I've got some of my customers who will actually call me and say, "Hey, Barry, I got a job going on, such and such address. They're going to be there, next Tuesday. Why don't you just stop by, go by, see what you see, good and bad." I'll say good and bad. I mean, it's an inspection. There can be some good things and there can be some bad things. So I've got customers that will do that. I've got one that emails me now periodically. She'll send me an email and say, "Hey, here's 3 or 4 places. Pick one. Don't let me know you're going by because I don't want them to know." And then other people, they'll plan it out. That's fine too. I've done it both ways. It works pretty good both ways. So if we can ever help you with that, that's what we're here to do. All right. Well, Sue is going to come and talk about some claims issues in just a minute.
I'm the claims representative for South Carolina, but I also handle Georgia as well. And I wanted to make sure that you guys have your book. I mean, that you've received one. I know y'all don't have one here today. But in this book, it has some very important information. But what I'm mostly here to talk to you about is the claim-specific information that's at the back of your book. First of all, how do you guys like to report your claim? Do you like to call it in, or do you like to email it? What do you think is the easiest? Personally, I think calling in is easier, but you can do it from the website as well. One of the most important things, though, is we want to make sure that these forms are completed properly and that you get all the information that you can at the time of the accident. We like, and I don't have one here, but a lot of times the companies will have their own incident report. Make sure that you get those filled out and do it at the time of the accident if you can. If it's a serious accident, sometimes you just can't do that, but get all the information, the witnesses' names, anything like that, because it's very important. If it goes into lost time and we do an investigation into the claim, we're gonna need those people to contact them. Because the employees, their stories change a lot. We found that out many times, and then you come to find out, it was just fraudulent. They hurt themselves the day before playing baseball or basketball or something, and they try to claim it as work comp, so then we'll deny that claim once we get all the information and it's investigated. A lot of times the medical reports will also substantiate what we had thought. You know, they'll say, oh, he said he was here 2 weeks ago and he had twisted his leg, and we told him at that time he had a tendon that was torn, and then he didn't report it to the employer, and then he has some little incident at work that's probably minor, but then it turns out to be a real big thing because he had that previous injury. Did you know we are a drug-free workplace? And that's getting ready. If you're going to be renewing your policies, that's something you're going to have to be putting in step. We will have all that information for you and show you how to do it.
Post-accident.
Post-accident.
Yeah, post-accident. That's what, if you're not a post-accident in South Carolina now, we're moving everyone to at least post-accident. Some of you already have that in place, but if you don't, go ahead and start considering it. Talk to somebody like me. I can help you get the information. It's pretty painless and it can help us out.
Yeah, and there's forms in here too, like a consent form, and in this folder, so that they can sign off on those. Because whenever you send them to the physician, make sure they drug test them. Because a lot of times they come back positive, and then you can deny that claim because they were under the influence. As long as it really did impair them while they were doing while they had their injury. If it was
There's also a link on our website, and it actually says on the right-hand side, provider lookup, and you can put in your address, and it'll give you people that we are in the Coventry network that we have negotiated rates with. And what I encourage people to do is, if you're at a stationary location, kind of like you are, find one of those doctors, go visit them beforehand, and say, anyone we send you, we need a post-accident drug test, and we want to get someone back to work. And so you have an understanding right away, and we actually have some back to work. We have a back to work program that we're starting to give out. Anytime we have a lost time accident, we have a packet that's automatically sent to the employer, for each one. And that's going to, it allows you to fill it out and the job duties and things that the employee could do, and you can give it to the doctor and say, can they do this, can they do this? And that'll, get them in a mode to where they're used to sending people back. So.
And also, if you look on the list and your physician is not on that list, and you would like them to be on the list, this is in the claims kit as well. This is for you to send in to us, and we can send it to Coventry to see if they can get that physician into the network for you. Sometimes they don't want to meet the criteria that fits for the network, and then they refuse to sign it, and then that's why they're not on or in the network. But we can always try to get them in there. He had mentioned the new Back to Work program. We would love for y'all to bring your employees back to work to some type of transitional duty if you can. One of the things that a lot of y'all don't understand is if they even come back to work and work less hours, we're still going to have to pay. We'll pay half of it though. And it also benefits the employee because it keeps them from sitting at home watching those commercials about.
And it keeps communication open, so you know when the employee has gone to the doctor. And there's a psychology to it. A lot of times when people get hurt, they automatically think they're in trouble. They don't want me to come back. They're mad at me. But if you created something and the employees come, you're saying, we care about you, we want you to come back. Plus, if somebody's more apt to malinger, if they're at work and they're doing a light duty job and they're starting to feel better, they'll be like, well, if I've got to do this and I'm feeling much better and the doctor's released me, I might as well go back and do my regular job.
Or if they're doing not so pleasurable transitional duty, they want to go back to that.
They want to go back to their regular job.
Exactly.
It's not so horrible anymore.
Right.
My favorite part about light duty has always been, if they're at your facility, if they're coming into work, you know where they're at. The only way they get off light duty is to go to their follow-up appointments and make their follow-up appointments.
If you have any questions or any problems, you always can give me a call. And my number is 3461, and I'm at extension 412. Very important that 412 is remembered, otherwise you're going to go into cyberspace somewhere else, you'll never get me.
Barry told you all who I am. I'm Debbie Brown. I'm with the law firm of Gallivan, White & Boyd. We have offices in South Carolina, both in Greenville and Columbia, and we also have a Charlotte, North Carolina office. And we handle the litigated claims for FHM, and have really enjoyed our partnership with FHM in handling those claims. So basically what we're moving from now, Barry has talked with you about preventing claims. Sue has talked with you about what to do, particularly when the claims are first reported. And I'm going to follow up just a little bit on that during my presentation. And then I want to talk to you some more, a little bit in depth, about the investigation of the claims and things that might be helpful to us as we go to hearings. And I am happy to take questions at any time. I've got a number of things in this presentation. Some things we've covered a bit already, and I'll just move quickly through those, or we may skip some portions of it altogether, but you all have a copy of it. So if I skip something and you have a question about the part that I have skipped, just let me know. But basically, let's see if this is going to work. Maybe if I turn it on, it will work. Sorry about that. Missed one little step in the technology there. But I think the overarching goal of all of us, as we talked about earlier, is getting the employee medical treatment, particularly when it's an admitted injury, and then getting the employee back to work as quickly as we can possibly get the employee back to work. And the accident investigation that we're going to talk about here today is a very important part in that process. When the accident investigation is done efficiently and effectively, it can be really helpful in terms of both from the adjuster's standpoint in determining whether to admit the claim or deny the claim, and then if the case reaches the point where it is litigated and I get involved or another attorney gets involved, then it is extremely helpful to us to have all of the background information that is done during the course of the investigation. And sometimes it may lead to, the investigation may lead to the treatment and the ultimate return to work. Other times it may lead to a denial of the case, but quite honestly, the denial is probably in a minority of the cases. But let's talk about those accident investigations. First of all, you do need to have some training for your supervisors, who typically are going to be the people doing a lot of the investigation. It may be your HR person, but have some training for those individuals to be sure that they know how to complete the forms and how to complete them properly. You'll want to be sure that they're talking not only with the claimant himself, but also the injured worker, but also with co-workers who might have information, and in particular with any other workers who may have actually witnessed the accident or been working around this person at the time the person contended that he was injured. And we pretty much always find that the most accurate information is the information that you get as soon as possible after you know that there has been an injury or an alleged injury. We want that information in close proximity to the accident. And that does help in weeding out the potentially fraudulent claims, because unfortunately those are there. And FHM does an excellent job. If there is a claim that may be fraudulent, they have a department who looks into that, handles that. And we don't see that with a lot of insurance companies, but FHM does an absolutely phenomenal job. That doesn't always mean that the person is going to be convicted with some type of criminal charge, but if it is fraudulent, they are going to look into it and handle it. As far as talking to the claimant, and I'm used to saying claimant because in South Carolina, once the case goes to litigation, the injured worker is called the claimant. So if you hear me say claimant, I am talking about the injured worker. But once you find out that there has been a claim reported, you need to talk with that injured worker face to face as soon as you can. Now, obviously, if the person's in the hospital As we talked about earlier, you need to kind of, depending on what kind of shape they're in, kind of gauge that in terms of determining when you're going to be able to talk to them. But assuming that the injury is not terribly serious, they are still there at your place of work, try to talk to them face to face, in your office, on the premises if possible. And as Sue indicated, utilize some of the forms. Get them to fill out a statement indicating what happened, and then have them, if they can fill out the statement themselves and sign it, that's great. If they need you to fill it out and then have them read it and sign it, that's okay too. There are some issues that you could run into with that. If you do a typewritten statement, or if you fill it out and then have them read and sign it, they may come back later and say, oh, but they didn't give that to me to read. That's not my signature. So you could run into some problems there. So sometimes it's good if they can actually fill out the statement themselves. I would highly recommend that you talk to the injured worker separately from any other potential witnesses or other coworkers, because you don't want everyone else in the workplace hearing the claimant's story, because then that may jade what they are going to tell you, particularly if they're friends with this individual. The other thing, be sure that you get the facts. You want the accident report to tell what happened, what the claimant said happened, what the other individuals say happened. You don't want to put in that report what you think. You may think that because this person said that this box fell off the top shelf on top of their head, your opinion may be that there's no way in the world, based on your safety procedures, that could have fallen and hit them in the way that they claimed that it did. But the investigation report is not the place to put that. Now, obviously, if you have opinions about the claim, when you're calling Sue or any other adjuster on the claim, absolutely let them know what you think, but keep it out of the accident report. Same thing, once I get involved or another attorney is involved, we want to know what you think about the claim. If you want to write down your thoughts and your opinions, you might do that maybe just in a separate piece of paper that you keep in your desk, not in the workers' comp file, not in the personnel file. Just keep the facts in places like that. And I work with some of you, I've worked with several of you in cases, and I know that those of you here today who I have worked with do a very good job in terms of your investigations and how you conduct them and the information that you put in your reports. But some of the questions that you might want to ask, particularly if you're talking to an eyewitness or just a coworker to see what they know, does their recollection of the incident match what the injured worker told you? Or before the injury, was that injured worker complaining of aches, pains, medical issues? And we get some good information, just word of mouth like that sometimes, particularly with back injuries, because you'll have someone come in, report a back injury, you start investigating, and you may have a coworker say, well, just a week ago, so-and-so was telling me that he's been getting medical treatment for injuries that he had to his back in a car accident last year, and he's still getting that medical treatment. So that gives you a pretty good indication that you're going to want to at least initially deny that claim to investigate it further. Another thing is whether the injured worker has requested or required any assistance, maybe previously in performing work activities, maybe meaning that they had something going on already. Is there any talk going on among the coworkers about alternate sources of injury? Maybe you've got someone who is, let's say, a race car driver. I had one of those recently, and races cars on the side, and the coworkers have heard that this person was involved in an accident on the racetrack the weekend before, and then comes in on Monday morning and reports an accident at work. Another thing to look at is whether there's any reason to believe that this injured worker was already unhappy with their job and maybe considering leaving the company. And one thing that's important there is whether this person has a lot of disciplinary issues, whether they have been maybe already given a couple of warnings, maybe to the point that their next warning means termination under your company policy. and they are concerned that they're not going to be there much longer, or maybe they know that they've just done something that maybe it's not obvious to you yet, but they know that they have just violated company policy a third time, and they're likely to get fired. So they may say, report an injury. It may be a legitimate injury, but under those circumstances, so many times it is not a legitimate injury. Also, something else to look at is the mechanism of the injury, is whether what the person was doing at the time they say they were injured, if that's something that's consistent with the injury they're claiming. Like, if they're claiming carpal tunnel or back injury due to repetitive motion, is your job repetitive in nature? Or do you work, maybe you've even had an ergonomic expert out, and you work hard to rotate your employees from job to job, or in certain industries you may have certain lifts that you use for patients to move employees. You work hard to keep the job from being repetitive in nature, and you know that they, if they're claiming a repetitive injury, or that maybe it's not really a valid claim. Another thing is, look at the workstation. In particular, if they're claiming a slip and fall, you want to be sure that there's not water or oil or some other surface on the floor. Check that out as close as possible to when this injury is reported to see if there was anything there. So you can see or if there's something strange going on with machine operations that particular day. Check that out to see if that's going to weaken the claim that's been reported to you, or it may make it stronger. This is really important, and this generally is something that you may not be doing as the employer, or you may run into ADA issues, but it is something that your carrier can do, that the attorney can do for you. But many times we win claims based upon the medical records that we're able to gather, generally the claims that we get prior to an individual's reported accident. I had a claim a number of years ago in which it appeared to be a very, very valid claim. It was a work-related motor vehicle accident. I've rolled over several times on the interstate highway. And there was a little bit of a question to begin with in terms of whether the guy was on his job when he was going from point A to point B. But we had basically determined that, yes, he probably was legitimately working, and it was in the course and scope of his employment when he was on the interstate highway. He was going to pick up checks for other workers. And he was injured, luckily not terribly badly, but we start gathering his past medical records. And we just keep getting in, one provider will get a stack like this, and literally our stack of prior medical records, and I am not exaggerating, ended up being this high for this individual. And he was probably mid-30s, maybe 40 years old. He was not an incredibly old individual. But then we start reviewing those medical records. And this guy had been injured, quote unquote, in virtually every fast food restaurant in the state with a slip and fall. He had had injuries at home, injuries with other employers, and even beyond that, more interesting than that, was the fact that some of these medical records, the doctors noted, when I walked into the room, he was going through the cabinets in the examination room. So I think that there was some drug-seeking behavior there as well. That was a fun case to try, and needless to say, we did win. We denied the case. We won the case. We don't get that lucky very often in terms of the past medical records, but we do get good information. Sometimes the medical records after the injury end up being helpful. In fact, Joe's here today. Joe and I had a case earlier this week, and we got in medical records for one of his injured employees well beyond the accident, after his former employee had been released at maximum medical improvement. And the guy had been to the hospital twice, reporting that he was playing basketball, injured his ribs one time, actually had a cut on his head from being elbowed in the head, and had to have stitches in his head another time. I think that's pretty strong evidence that he was not having many problems with his back anymore. We're waiting to see if the commissioner thinks it's strong evidence, because he explained it away. He didn't have basketball in his hand. He was just conditioning to see what he could do. I don't believe him for a second. I know that Joe doesn't believe him. We'll see if the commissioner believes him. But in any event, these medical records can be very helpful. But even though I'm telling you this, just be careful. Don't do anything that's going to cause you to run afoul of the Americans with Disabilities Act. Talk to Sue, talk to me, and we'll be glad to help you see if we can get medical records. Okay, and as the person's treatment goes forward, we have to look at what the person is reporting to the doctor. And sometimes the story is very, very consistent. They tell you, this is what I was doing when the injury happened. You send them to your company doctor. They tell the company doctor exactly what they told you. The company doctor refers them to an orthopedic surgeon. You get exactly the same story there. But you would actually be amazed at how often we see medical records where that story changes. And Joe did everything great in his case. So I'm not pointing him out for doing anything wrong, because he didn't. He did everything right. But his claimant did everything wrong. And this was another incident. He told Joe one thing about what happened. They send him to the doctor. He tells the doctor, something very general, and not really contradictory, but just really, really general. This guy gets referred to several other doctors, and literally his story changed every single doctor he went to. It went from his back being sore from raking leaves to being hurt as he was raising the gate on a trailer, to being hurt as he was lowering a gate. And then I take his deposition, and he has this very, very detailed story about some springs not being placed on the gate correctly. And when he and a coworker are lowering the gate actually hits him, knocks him to the ground onto his back. That's not in a single medical record in the case. So, it's really amazing, how people's memory either is not very good, or they really did not get injured. So they just come up with the story of the day and report that to whichever medical provider they happen to be seeing. You also want to look at the prior medical records to see if maybe there's a previous injury there that could be actually causing the problem that the person is having now. Now, I will tell you that in South Carolina, it is fairly commonplace for our commissioners to say that even if the person had a prior injury, that they may have aggravated or exacerbated that injury with whatever they are reporting to you happened at your workplace. And if the commissioner determines that it is that the prior pre-existing condition was aggravated or exacerbated, then unfortunately you are going to be on the hook for that. And I think that we've pretty much talked about the rest of that there. Let's talk just a little bit about malingering, because we talked already about how important it is to get people back to work. But sometimes you see the claimant's attorney send them to a doctor for treatment. And they're typically doing that for any number of reasons. Typically they're going to send them to someone who they know is likely to give a fairly favorable report. The claimant's attorney is paying for the person to go there. But sometimes they're just trying to drag the claim out somewhat. We also sometimes have cases where, say Sue's going to set an appointment, or the nurse working with Sue may set an appointment for the individual, notify the individual and the attorney of the appointment, and then sometimes even unbeknownst to the claimant's attorney, the claimant calls the doctor, oh, I've got to pick up my child, or I've got to pick up my grandchild that day. I can't come that day. Let's change that appointment. Oh, no, let's do it about a month down the road. They're just not real interested in getting, in having their medical treatment move forward. And if you were truly injured, I know if I was truly injured, I'm going to want to get my medical treatment as quickly as possible because I want to get well. So that certainly makes you wonder, if somebody does it one time, it may not be a big deal at all. But if somebody just repetitively goes in and keeps changing appointments and pushing them back, that is certainly a sign that they may be malingering. If they're not cooperating with the doctor, You know, if the doctor's telling them certain things to do, they're not doing it. The doctor prescribes medication, person goes back in 3 or 4 weeks, and, oh no, I decided I didn't want to take that, or no, I haven't gone to the pharmacy to get that filled yet. And like Sue said, you provide the pharmacy, FHM provides the pharmacy cards to them, so there really is no reason for them to do that. I mean, sometimes we may see that there might be some sort of personality disorder coming into play here, or like I mentioned earlier, you know, if you see drug-seeking behavior, sometimes that is a very, very good indication that there maybe was never an accident in the first place, that this person just maybe has had accidents in the past, knew when they had accidents in the past, they got these drugs that they liked, and they go in and try to repeat the process to get the drugs again. You know, another thing as far as the drug-seeking behavior is concerned, often we see pretty much all of the pain management doctors in the state, for the most part, are very good about performing periodic drug tests on the individual, and they do that for 2 reasons. One, to be sure that the individual is taking the medication that was prescribed for them, and second, to be sure that the person is not taking some sort of illegal substance. And most of those doctors, particularly if there's an illegal substance, they've already had that patient sign a contract, and as soon as they determine that there's an illegal drug, they basically release them from their practice. Doesn't always win a claim for us. Lots of times this happens even in admitted claims. I've got a claim now that unfortunately I've had for a few years where the guy was badly injured. He's had several surgeries along the way. He's basically at MMI. We're trying to settle the case now, and he's been going to pain management probably for 4 years. This summer, positive drug test, and the drugs that the doctor was prescribing were not in his system. You know, he comes back in one more time because, you know, the doctor has to get the reports back, and his sob story is that his wife had taken his prescribed drugs. She was taking those, so he used marijuana. He said he was no longer with his wife, that they were separated at that point because of this. So, you know, we are finally, because it's a pretty big case, it's taking some time to get authority. So we are right now trying to get the guy in with another pain management doctor, because we don't want him, you know, totally going out on the street and doing things. But I get sob stories on at least a weekly basis from his attorney. You know, once in 5 years, he smokes one marijuana cigarette. You know, yeah. He believes him. I don't believe him. But anyway, you're going to want to look at these factors as a whole. And if you've got several of these factors, then there is definitely the potential that you may have a fraudulent claim on your hands. Like, for instance, if the claim occurs early in a workday, particularly on a Monday, I mentioned that before, maybe the person's been hurt over the weekend, and they at least kind of hidden it as they come into the workplace, but they stage an accident early in the day. Or, you know, the opposite, the claim occurs late in the workday, or particularly on a Friday afternoon. And maybe that's somebody who's just wanting to get off of work early. You know, anytime a claim is not witnessed, and a lot of times there are very valid accidents where the claim is not witnessed, but particularly you want to look into those carefully, or maybe it's the person's best friend who witnessed it, or you might have an employee, a relative who's working there as well who witnessed it, or you might have the most disgruntled employee in your workforce there, and that just so happens to be the person who witnessed this claim. And then, like we talked about earlier, claims that are not reported for several days or even for several weeks. And I think the gentleman in the back had asked earlier the time frame for an employee to report a claim. It is 90 days, but I will tell you that what the commission here in South Carolina and the courts here in South Carolina consider to be notice is a pretty liberal standard. It does not take a whole lot for the employer to be put on notice of a claim. I had a case a few years ago where the employee did not report the claim. but was out of work, went to the doctor, had a shoulder problem, shoulder injury. And the doctor faxes in a statement saying so-and-so needs to be out of work for 3 days due to her shoulder injury. Didn't say her shoulder injury at work, never said anything about a workers' comp accident. She didn't report anything, but because that one fax arrived on their fax machine within that 90-day period, that was found, and this even went to the appellate courts in South Carolina, and this was found by the South Carolina Court of Appeals to constitute notice within the 90-day period. So I'm not saying you're never going to win a claim with a notice defense, but I will tell you that it is not easy to win claims with a notice defense test. One thing that I do want to mention as far as drug testing is concerned is, and this is similar but a little bit different from what was said earlier, if you have a company policy that provides for a person to have a post-accident drug test, but this person maybe you saw them on the floor even, and you go talk to them and the person says, oh, I don't want to report this, I'm not going to pass a drug test. Send that person for their post-accident drug test at that point in time. I actually have a claim pending right now in which the person possibly fell on the floor at work, was injured, did exactly that, said, you know, I'm not going to pass a drug test. At that point, the company did not think that the injury was serious, did not appear to be serious, so they decided just to kind of handle it on their own. And in fact, they didn't even pay for the medical treatment. The lady went to the doctor on her own. But then about 4 or 6 weeks later, when it became obvious that she was being referred to surgeons, that the injury was more serious than it had been initially, then they started getting really concerned about it. You know, again, you know, like we said earlier, just because there's a positive drug test doesn't mean that you're going to win the claim as an employer. But this lady was just concerned that she was going to get fired. Surprisingly enough, once the doctor released her to return to work, they did have her have a return to work drug test, actually at my suggestion, but it was also positive, but they put her back to work. Haven't quite figured that one out yet. In any event, you do need to pay attention to what the employee says about drugs. Sometimes employers think that just because a person has reported a workers' comp claim, that their hands are kind of tied then as far as personnel decisions are concerned. That is really not the case. If that person does something, you know, whether it was in the course of being injured or particularly something that occurs after they're injured, that you would discipline any other employee for, you need to discipline that employee as well. You don't, but what you do have to be careful about, I know Barry mentioned the employer who was really mad to the point that they could not go to the hospital to see the employee, and I can agree it's probably a good thing they did not go, because had that person in that frame of mind gone to the hospital, he may have walked in and said, you're fired right now because you got hurt. I can guarantee you that within a week they would have been served with a retaliatory discharge lawsuit. So you do have to be careful how you handle it, but as long as you're not relating discipline to the claim or kind of spouting off about the claim, even though the discipline has nothing to do with the claim, then yes, absolutely, you can and you should handle the person and treat the person just as you would treat any other employee as far as discipline is concerned. But on the Form 12A, I really just want to say one thing. This is the first report of injury, and I know some of you said that you call them in as opposed to completing them yourselves. But if you complete it yourself, I would suggest that somewhere on that form, maybe when you're describing what the employee says occurred, that you just put that this employee alleges that she fell and hurt her knee. You know, maybe just throw the word alleges in there somewhere. And the only reason I'm saying that, the Form 12A is not evidence, not supposed to be evidence. It is not an admission of liability. But I have seen commissioners in the past during hearings sit there, and if they're hearing one thing being testified to, they'll thumb back when they used to have physical files. They would thumb through the files, and then they would start saying, well, the first report of injury says, I don't think that that happens quite so much with our current commission as it did with some of our prior commissioners. But I still like to see, if it's a legitimate injury, you don't have to worry about putting alleged. But particularly if you have any questions about the injury, it does not hurt to throw the word alleged on there. Okay, the Form 20. I know that Sue told you probably about 3 times already how important it is that you complete this Form 20 when you receive it from her or whoever is sending it to you. I do want to reiterate that because like she said, it's not difficult to do. If you have any questions about it, she's happy to help you. I'm happy to help you. But we got these Form 20s filled out wrong so often for a form that really should not be a difficult form. I mean, Sue sees them all the time, I see them all the time, but you guys don't necessarily see these Form 20s all the time. So I understand that it's not something that's commonplace for you, but I have had the Form 20s filled out where the person's correct wage information is included in there for the 4 quarters preceding the date of injury, basically the wages you would be reporting to the Employment Security Commission, and then you divide that by the number of weeks the person worked. Typically, in most years, that's going to be 52 weeks. But a lot of people get paid every other week. And I have had Form 20s come in, and they are divided, even though the person worked the entire year, the annual wages are divided by 26 as opposed to 52. And I had a case at one point where I actually I did not get, I got the claim, it was an admitted case. The person had quite a bit of medical treatment, so it was a while before the case was litigated. So this individual had been paid weekly benefits for quite some period of time before I saw the Form 20. And then we started looking at the Form 20, and we saw that it was one of those situations where it was divided by 26, which basically meant for about 2 years, if I remember correctly, this injured worker had been paid double, which basically meant that she was making more in her weekly wages than she would have been making had she been working. Did she have any incentive to go back to work? Yeah, no. And then, obviously there's such a huge credit at that point in time that sometimes that makes it difficult when you're trying to settle a case. And we did eventually settle that one. We debated taking it to the commission, but I've never taken one to the commission with that large of a credit, which literally could have eaten up everything that this employee might have been entitled to in terms of disability. So I can't tell you what the commissioner would have done with that one. She might very well have said that the employer or the carrier should have caught that sooner than it was caught, and that and this was not an FHM case. I will give you that disclaimer. This was not an FHM case, but the Form 20 is really important. And like Sue said, sometimes if she doesn't get the Form 20, she has to get those weekly benefits started. So she may have to rely upon the estimation of wages that's on the 12A, the first report of injury. And a lot of times that's really accurate, but sometimes if you have a person who has been just not showing up for work, a day every other week, or maybe the person had some sort of prior medical condition and they missed 6 weeks from work during the course of the prior year for a medical condition, it may be that their average weekly wage is a lot less than you're going to get if you multiply what is shown on the average wage, looking at the hourly amount times 40 hours per week. So it is important that the Form 20 be completed quickly. There are time frames for doing that as well, then basically the person, and you probably all know this, gets 2/3 basically what their average weekly wage is. I'm going to talk just very briefly about some defenses and claims. We've talked about notice already. Statute of limitations, there is a 2-year statute of limitations for a person to file a claim. But basically, as long as the commission is put on notice that the person may have a claim, and that may be nothing more than an attorney sending a letter of representation to the commission saying, I represent this individual in connection with their workers' comp claim that occurred with this employer on this date. They may not file a Form 50 requesting a hearing for another 3 years, but the statute of limitations is told as long as the commission is put on notice within 2 years. Intentional acts, we don't see a whole lot of this, but it does happen. And if a person somehow intentionally injures themselves during the course and scope of employment, that is a valid defense. One of the best situations I have seen on this was not my case. Another attorney in my firm had this particular case, and I'm not real sure what led up to this, but a group of workers decided that, hey, we're going to put this coworker up on, one of these dollies, like you would move boxes with. They used duct tape to tape him very well to that dolly. He's standing up on it. And then they take him and they shove him down a fairly long set of steps. And he was injured pretty badly in the course of this. That attorney's now on military leave, so I couldn't go back to him and get him ready for this and say, what was the outcome of that case? I think that because of the fact that even though this guy may have had a little bit of involvement in the horseplay maybe at the beginning, what is important is the injured worker's intent. This guy clearly did not intend to be pushed down a long set of steps and get injured, and I think that the claim eventually was found to be compensable. But you don't see people doing things. You see stupid things. I know you don't often see things quite that stupid. We've talked about intoxication already, fraud in the application. And I think somebody mentioned earlier, maybe somebody not putting correct information in the employment application. And particularly if you do have a post-employment questionnaire and the person fails to include information, let's say the person had a prior back injury and the doctor released the person and said, you've got permanent work restrictions of no lifting over 25 pounds. And then you hire the person, they don't reveal this in the application process or the post-application process. The job that you hired them for involves lifting more than 25 pounds. The person injures his back lifting more than 25 pounds in your workplace. In that situation, because of the fact that had you been told during the application process that the person had these permanent restrictions from the prior injury, you likely would never have hired that person. And then when they get injured, they're injured because they were doing the type of work that they had previously been told by the doctor not to do, that they did not tell you that they were not supposed to be doing. So that could be a valid defense. Now, having said that, if that same worker with those same restrictions comes in and there's water or some substance on the floor and they slip and fall, so the mechanism of injury has nothing to do with the prior accident and the prior restrictions. The fact that they failed to tell you about that prior accident probably is not going to be a valid defense in that situation. Last injurious exposure, there's a case that came out a few years ago called the Gathers case, which some of you may be familiar with, and you may have heard if you've had comp claims, and particularly if you've had someone move from another employer where they had an injury to your place of employment, or were injured at your place of employment and then moved to a different employer, you may be able to bring in the second employer and say, yes, this person was injured at my workplace. I've been providing medical treatment. I provided weekly benefits for a period of time. But then they go over to this other employer and they either re-injured themselves there, or I think that they're doing a repetitive job that's aggravating the injury that they had when they worked for my company. And in that situation, if you are able to prove that the person is aggravating or that they re-injured themselves at the second employer, that might get you off the hook totally from that point forward. You're not going to get reimbursed for anything that you've done before then, but it might get you off the hook. Subsequent intervening accident, we do not see a whole lot of this that we can really use. Sometimes people do get involved maybe in a car accident or something after they've had the accident, but if it happens close after the work accident, it's maybe difficult to use it. If the person is at maximum medical improvement or close to maximum medical improvement, then you may very well be able to use it. I've got some statistics on here. I think one of the most important things actually is just kind of derived from these numbers, but it's not on here, and that is in this time frame that we've got on here, I believe that it was 70-something thousand workers' comp claims were settled, never even made it to the commission. So a lot of claims do get settled. I think that Barry is giving me the signal that I am getting close to being out of time, but following up on what I just said, because I do get questions from employers a lot as to why we settled a case, or, why did, maybe the settlement is not an issue, but why we paid that amount of money to settle a case. And I will tell you, first of all, that I would hope, and I do know with FHM, in most instances, you're going to be involved, at least to some extent. You may not have the right to make the call as to whether the case settles or doesn't settle, or whether it settles for amount X or amount Y. But I know that FHM is really good about consulting employers to talk with them about the case before they settle it. But sometimes particularly when you're looking at the amount of money the case settles for, sometimes it's just very much a factor that comes from the person's compensation rate and the amount of money that the person is making. And you look at the number of weeks that the body part is worth, look at the impairment rating that the doctor has given, and that adds up in a hurry. Sometimes it's really astounding how quickly it adds up. But there are factors on here that you can look at that we consider in settling a case. I think that we've talked a lot about this one already, about pre-existing injuries. We've talked about drug screens. Earlier, we talked a little bit about an employee insisting on going to their own doctor. I would say no, that you need to get the employee to your doctor, not to the doctor they want to go to, because they may have a history with that doctor. They may know that they can go to that doctor. That doctor is going to give them whatever drug they ask for. You want them to go to your doctor. Second opinions, this is important. Right now, in particular, our commission, almost 100% of the time, if the employee asks for a second opinion, is going to tell the carrier that they need to provide a second opinion. So typically, if they ask for it prior to a hearing, we go ahead and provide it. Sometimes people ask me, well, what's the commission like now? Is it employer friendly? Is it injured worker friendly? And those of you who have been doing this a while know that for a number of years, our commission was not particularly employer friendly, but that has improved. The commission overall is much more employer friendly now. I think that we've got a good group of commissioners now. Unfortunately, that doesn't mean that we win every case, but I do think that we have a group of commissioners who will weigh the evidence, look at both sides fairly, and then make the determination. Safety rules violation, no fault system in South Carolina. So just because a person violates the safety rule does not mean that they do not have a workers' comp claim. I think we talked about the next one there. We talked earlier about light duty employment, which is really important. If you have light duty that a person can do, I would highly recommend that you get them in and have them doing that light duty work for any number of reasons. This one, if the employee contends that they're hurting, doctor says they're fine, we see that a lot. Sometimes we just go to the commission with that. Sometimes we try to get a second opinion just to confirm that the first doctor is correct, that the person really is fine. Okay, I think my time is about up, but are there any other questions? Okay, thank you all for your attention.